Good evening and welcome to this meeting of the Ottawa-Carleton District School Board on the 19th of December, 2023. Seeing quorum in the room, I would like to call the meeting to order, acknowledging that we are meeting tonight on the unceded and unsurrendered ancestral homelands of the Algonquin Nation. We thank the Algonquin people for hosting us on their land, and I ask that in our meeting, we be mindful of the teachings of traditional Indigenous value systems, which focus on shared wisdom, protection of the land, resources, and children, gratitude, humility, honor, trust, balance, and love of doing well unto others and preventing harm to others. In accordance with the Municipal Conflict of Interest Act, does any board member have an interest to declare? Seeing none, I would like to move to the report from Committee of the Whole in camera. Vice Chair Milburn, would you please present your report?
The board met as Committee of the Whole in camera this evening, and there were no recommendations.
Thank you. That brings us to item 5 on the agenda, approval of the agenda. Do we have a mover to approve the agenda? Trustee Blackburn, thank you. Seconded by Trustee Dixon. Is there any discussion on the agenda? Seeing none, I will call the question then on the agenda as presented. All those in favor and opposed? The motion is carried. And now for the chair's briefing. I am very pleased to share that today the Ontario Public School Boards Association announced it has ratified the tentative agreement reached with teachers and occasional teachers of the Elementary Teachers Federation of Ontario, also known as ETFO, on the 21st of November. This comes following the announcement last week that the majority of ETFO members voted in favor of this agreement. Central collective agreements are now in place with both the elementary and secondary teachers federations. And as a result, there will be no provincial labor actions in English public schools across Ontario over the next three years. That's all my briefing tonight. Are there any questions? And no questions, so we move on to the next item, which is briefing from the director. Mr. Director.
Through you, Madam Chair. Thank you very much. Good evening, everyone. As we approach the 2-week break in our school year calendar, I wanted to take this opportunity to share a few important reminders. The last day of school for elementary and secondary students will be Friday, December 22nd. All elementary and secondary schools, including school offices, early on child and family centers, and OCDSB administrative sites will be closed at the end of the regular hours on Friday, December 22nd. Secondary school offices and OCDSB administrative sites will reopen on Tuesday, January 2nd. Elementary offices and early on child and family centers will reopen on Monday, January 8th. All students will return to class on Monday, January 8th, 2024. Many families within our communities will be joyously celebrating various holidays this season. Whether you observe the winter solstice, Yule, Yalda, Christmas, Kwanzaa, Zarathushtri, we extend our heartfelt wishes to all participating in these festivities and these festive occasions during the winter holiday season. I hope that students, staff, and our school communities can take the time to rest and relax. We look forward to welcoming you back in the new year. Thank you.
Thank you. Are there any questions for the director? And seeing none, that brings us to delegations. And this evening we have no delegations on our agenda. So we are now at confirmation of the board minutes from the 28th of November, 2023. Do we have a mover? Trustee Lee, thank you. Seconded by Trustee Nash. Are there any errors or omissions? Seeing none, I will call the question. All those in favor of confirming the minutes? And opposed? The motion carries. Is there any business arising from the minutes of the 28th of November, 2023? Seeing none, I would like to move on then to item 11, matters for action. And I now call on Vice Chair Milburn to present the report from the Committee of the Whole meeting on the 5th of December, 2023. Vice Chair Milburn,
I would now like to move receipt of the Committee of the Whole meeting minutes from December 5th, 2023.
seconded by Trustee Presley. Thank you. Are there any errors or omissions in this report? Seeing none, all those in favor of receipt and opposed, and that motion is carried. Vice Chair Milburn.
The Committee of the Whole met on December 5th, 2023, and reports and recommends as follows. On a motion by Trustee Aziz, which I will second, your committee recommends that staff develop an analysis of needs in the following areas as part of the 2024 to 2025 budget process: transportation, special education, mental health and well-being, cost pressures related to facilities renovations and new builds, employee replacement costs, and cybersecurity.
Is this a consent item? Seeing no objection, we will take the vote on this after item 11.3 on our agenda. Vice Chair Milburn, anything else?
That concludes my report.
Thank you. And now for the report from Committee of the Whole Budget from 11 December 2023. Trustee Lyra.
I'd like
could
to
you
move
present?
receipt of the Committee of the Whole Budget Report from the 11th of December, 2023.
Thank you. Is there a seconder for that? Trustee Jenkins. Are there any errors or omissions in this report? Seeing none, all those in favor of receipt? Opposed? And the motion is carried. Anything else, Trustee Lyra?
There were no action items, so no.
Thank you. And now we are at the report from the Ad Hoc Policy Review Committee on the 7th of December, 2023. Vice Chair Milburn, could you present the report?
I would like to move receipt of the report from the Ad Hoc Policy Committee dated December 7th, 2023.
And is there a seconder for the motion to receive? Trustee Blackburn, thank you. Are there any errors or omissions in the report? Seeing none, all those in favor of receipt and opposed, and that motion is carried. Vice Chair Milburn?
The Ad Hoc Policy Committee met on December 7th, 2023, and reports and recommends as follows. On a motion by Trustee Blackburn, which I will second, that the proposed amalgamated policy P.035.SCO extended day and childcare programs attached as Appendix A to Report 23-078 be approved, and that the standing policy P.059.SCO childcare programs in schools attached as Appendix B to Report 23-078 be rescinded.
Thank you. Is this a consent item? And seeing that it is, we will take the vote on consent items, on all consent items in just a moment. Is there anything else, Vice Chair Milburn?
That concludes my report.
Thank you. Manager Guthrie, could you please open the vote in eScribe for the two consent items, namely the needs analysis motion regarding the 2024-2025 budget that is coming from Committee of the Whole, and the policy decisions that have been recommended by the Ad Hoc Policy Review Committee? We're waiting for Trustee Bell.
eScribe is not opened up on my computer. I'll recharge it. I vote in favor of both. Thank you.
Thank you. And we have a result, and that is 11 in favor, none opposed, and one abstention. And of course, the student trustees do not have a binding vote. So the motion is carried. Both motions are carried, and we have no non-consent items. So we will move on then to item 12.1, which is the investigative report with regard to board member code of conduct. And do we have Ms. Craig with us? We will take a 5-minute recess before proceeding on this item.
Trustee Scott, I'm just wondering if we did have a non-consent item, the needs-based analysis.
I'm sorry, we
vote on.
can't hear you properly.
Do we have one non-consent item, which is the needs-based analysis to vote on?
No, that was a consent item.
Oh, okay, great.
Yeah. Yeah. So that's why I said that was. Yeah.
Chair Scott, your mic is on.
having some technical difficulties, and I expect it will take at least another 5 minutes to get them resolved. Thank you for your patience. Good evening again. We seem to have resolved our technical difficulties. And we will now proceed with item 12.1 on our agenda. I would like to welcome Integrity Commissioner Suzanne Craig to present her formal investigative report and global findings in response to complaints she received regarding Trustee Donna Blackburn, Trustee Donna Dixon, and Trustee Neely Kaplan-Mirth in accordance with Board Member Code of Conduct Policy P.073.gov. Allegations of breach of the board member code of conduct have always been difficult to navigate fairly and objectively, and are especially challenging for the respondents and the complainants. In our discussion and debate on this agenda item, I expect and will enforce a high standard of civil discourse focused exclusively on the matters before us. Any disruptions, whether by those at this table or by members of the public in attendance, will not be tolerated, and any person creating a disturbance may be required to leave the meeting. And now over to you, Ms. Craig. You have the floor.
Thank you. Chair Scott, Vice Chair Milburn, Board Trustees, good evening. I'm here this evening in the capacity of the Integrity Commissioner for the Ottawa-Carleton District School Board, presenting my fact findings and recommendations to you, the board, the decision maker, on 3 separate code complaints, naming 3 trustees as respondents. Given that the allegations of the complaints related to conduct around the same events and in close proximity timelines, I've decided to combine the review and fact-finding into one investigation. To be clear, I have treated the review of facts relating to each respondent trustee separately. I will provide a brief overview of my fact-finding and recommendation work, after which I will take any questions you may have regarding process or if you seek clarification. I would like to remind trustees that I cannot provide answers on the merits of my fact-finding or recommendations. Questions on merits will be answered in the report, which you will deliberate on as decision maker. The board is given statutory authority by the Education Act to create codes of conduct to regulate the behavior and conduct of trustees. Under the Education Act, under the heading Code of Conduct, a board may adopt a code of conduct that applies to members of the board. A member of the board who has reasonable grounds to believe that a member has breached the board's code of conduct may bring forward an allegation of breach to the attention of the board. Your code sets out a procedure that the board's integrity commissioner will follow upon receipt of a code complaint a procedure that you have approved. Sections 4.40 and 4.41 of the code set out that if the board determines that a trustee has breached the board's code of conduct, the board may, 1, censure the member, 2, bar the member from attending all or part of the meeting of the board or a meeting of committee of the board, 3, bar the member from sitting on one or more committees of the board for the period of time specified by the board not to exceed 6 months. As Integrity Commissioner for your board, the board has delegated its fact-finding and investigating duties to me. I act as arm's-length independent accountability officer within the integrity regime created by the board that includes the rules of the board member code of conduct, recently updated in May 2023. This governing document approved by you sets out the ethics rules that trustees have collectively agreed to follow. Contained within the approved ethics document is the complaint investigation process, the Integrity Commissioner's duties, the provision of advice to trustees on the application of code rules, training and education, informal complaint mediation, and formal complaint investigation, in which I act as the fact finder with recommendations to you. The complaints at issue in this investigation relate to trustee closed meetings, public social media, and media interactions. Disclosing the identity of the trustees who filed the complaints, in my view, serves no purpose. All the respondents were able to respond to the complaints without knowing the name of the complainant trustees. I have chosen not to disclose these names in the report as I believe the persons who filed the complaints is not necessary for you to know to understand my findings. I discussed with each of the respondents certain particulars of the complaints. Because one complainant raised with me concerns about reprisals for bringing forward the complaint, I have exercised my discretion to disclose to the respondents and in this report only those particulars that I have determined were necessary for the respondents and the board to understand the substance of the allegations and the reasons for my findings and recommendations. In particular, I did not disclose the names of the complainants to the respondents, nor did I disclose the name of the witnesses or other individuals with whom I spoke. On December 6th, 2023, I was advised that Trustee Kaplan-Murth disclosed documents relating to this investigation, including her legal counsel's legal reply to the complaint, her factual reply to the complaint, the appendix to the September 29th allegations, and my confidential draft findings and recommendation report relating to her. Section 4.22 and 24 of the code state, the complaint, any response to the complaint, and the investigation of the complaint shall be confidential until it is before the board for a decision as to whether or not the respondent has breached this policy. Section 424 states the formal review will be conducted in private and to the extent possible protecting the confidentiality of the parties involved. This December 6th disclosure is contrary to the cited code rules. In the current circumstances, however, I have decided not to add a supplementary finding of breach of confidentiality with respect to this circumstance in my findings report. However, I am not condoning this action, and in the future, this type of action may be met with sanctions. Pursuant to Rule 4.13D, I'm required to not investigate a complaint where there are no grounds or insufficient for the complaint. This is a very low threshold. I reviewed the complaint and supporting documentation very carefully with respect to each respondent individually. Although complaint 2 did raise issues that appeared to rest on assumptions and influences unsupported by alleged facts, and also irrelevant or dismissive allegations that would not on their own establish sufficient grounds for review, I nevertheless determined that taken as a whole, complaint 2 did disclose sufficient grounds for an investigation. The objective of a code complaint investigation is to discover facts upon which the board can make a reasonable decision on whether there has been a contravention of code rules. As a procedural safeguard, as Integrity Commissioner, I have applied the established best practice of speaking with an individual complainant and conducting a preliminary review prior to deciding whether or not to commence an investigation. This practice was followed in this case. I am required to evaluate the evidence and facts on a balance of probabilities and make factual findings. I'm then required to make recommendations to you. I provided the respondents with the details of the complaint, and they were given an opportunity to respond to the allegations in writing. I received complaint 1 on September 19th, naming trustees Blackburn, Dixon, and Kaplan-Murth as respondents. I received complaint 2 on September 22nd, naming trustees Blackburn and Dixon as respondents. I conducted a preliminary review classification to review and determine that the complaint was a matter that triggered the code. On September 29th, I provided the trustee respondents with notice of a complaint investigation in relation to that complaint and asked for their written response. On October 1st, I provided trustee Kaplan-Murth with the same notice in relation to complaint number 1. On September 30th, October 11th, and October 12th, respectively, I received written responses from trustee Blackburn, trustee Dixon, and trustee Kaplan-Murth to complaint 1. On October 16th, I forwarded the notice of complaint 2 to trustees Blackburn and Dixon. On the 16th, I also had separate telephone conversations with trustee Blackburn and Dixon and received their oral response to complaint 2. On October 17th, I received a supplementary written response from trustee Dixon to complaint 2. The balance of probability standards of proof requires a finding that is more likely than not that an alleged event has occurred and requires that this finding is based on evidence that is clear, convincing, and cogent. The majority of code of conduct complaint investigations include receiving information from various sources that are contradictory, which raise the application of believability. A witness statement that is not credible is not reliable, but testimony that is credible may nevertheless not be reliable. To illustrate this challenge, in one decision, as I set out in the report, and I will read here, demeanor is not a dependable indicator of either. Although the demeanor and apparent willingness and ability of a witness to resist any influence of self-interest remains a legitimate consideration, appearance in the witness chair can be a poor indicator of either credibility or reliability. Unless one knows an individual well enough to be able to identify his or her tells, witness chair demeanor rarely offers the reliable clue to credibility. As Integrity Commissioner, I am not required to include everything that I've received and upon which I relied to make my finding in my report. A divisional court stated, and I quote, "A tribunal's reasons do not have to include all the evidence that the tribunal heard. They merely have to allow the reviewing decision maker to understand why the tribunal made its decision and permit it to determine whether the conclusion is within the range of possible and acceptable outcomes." During this investigation, I received the respondents' opinions, beliefs, feelings about what was allegedly said or done by others in the course of the events subject of this complaint. However, while I listened to all witnesses and others with whom I spoke briefly on the matter to obtain context and get insight into possible motivation for conduct, my role as Integrity Commissioner fact finder was to determine if on a balance of probabilities, the conduct alleged to have occurred. And if this conduct was contrary to the rules of the code. I was not tasked with identifying every past alleged aggression, wrongdoing, slight that every named respondent and trustee may have committed in the past year. Nor was I tasked in this complaint with determining a hierarchy of wrongs. For example, this person did this more than that person did. I relied on factual evidence as distinguished from feelings or belief about why someone acted the way they did for the purpose of my findings of fact and a determination of whether there have been violations. For the most part, oral statements, emails, media, social media communications, were not in dispute and were available to review online or otherwise available to me through transcripts, audio, and video recordings. The determination that something was said is a finding of fact. The determination that what was said likely may violate the code rules is a recommendation of sanction that you must make a decision on. As I set out in the report, Section 440 of the code says, if the board determines that a contravention occurred, although the board member took all reasonable measures to prevent it, or that a contravention occurred that was trivial or committed through inadvertence or an error of judgment made in good faith, no sanction shall be imposed. Generally, the jurisprudence has found that to decide inadvertence or error in judgment in good faith, there must be some diligence on the respondent's part. That is, some effort to understand and appreciate their obligations under the code. Outright ignorance of what their obligations entail or not caring what the rules prescribed will not suffice, nor will willful blindness. Generally, if there is some diligence respecting a trustee taking steps to understand their obligations under the code, and if they nonetheless breach the code, it may be deemed by you inadvertent or made in good faith, and the board may conclude that the trustee under investigation either acted in good faith or contravened through inadvertence and is saved from the imposition of sanctions. The key dispute in this complaint investigation related to the characterization of what was said and whether it amounted to a breach of the code. I've addressed these issues in the individual findings reports. There has been ongoing vitriol and despicable hate speech and threats directed at Trustee Kaplan-Murth. The authors of these despicable, hateful comments, threats, and vitriol were not the other trustees named in this report. Information that I received from witnesses, including staff, set out that there were security protocols followed on September 11th with a view to facilitating the safety of all trustees, staff, and the public in board facilities. The details of the security threshold for entry and denial of entry of persons into the building that evening were not shared with me. However, to ensure the integrity of the building and safety and security of all in attendance, I understand from the information received that there were protocols put in place to monitor who could enter. Thus, I concluded that based on the security protocols in place, all who sought entry were evaluated based on the known risk at hand. At the end of the document before you, I've submitted 3 separate findings reports regarding 3 respondents named in the complaints. As the board's integrity commissioner, I've made findings and recommendations to you to assist you in making a decision on whether there has been a breach. I've recommended that the Board of Trustees accept my fact findings. The attached global report includes a detailed summary of the procedure, results of the investigation, findings, recommendations. I've also made recommendations that the Board of Trustees, as a way of expressing their commitment to the Code of Conduct, take into consideration the importance of each trustee's fiduciary obligations to the collective board. I just want to spend a little bit of time on the length of the report. Throughout this report, I've endeavored to set out the facts and I've gathered throughout this investigation in a way that would make sense to the Board of Trustees, whose task it is to make a decision. Upon receipt of these complaints, I anticipated that the investigation would be concluded quickly, given most of the alleged conduct referred to matters documented in print and recordings. However, during discussions, some of which were official requests for interviews, I determined that there was a need to gather more information to determine the facts that were not in print and related to some of the allegations of the complaint. The report may seem lengthy. However, the first complaint named 3 respondents and the second complaint named 2 respondents. Of course, 2 were the same as 2 in the first complaint. In short, this was not a complaint about one individual trustee. The length of the global findings report underscores the amount of information I received and reviewed, principally because many with whom I spoke provided different perspectives on the same events. The global report setting out the facts relating to the allegations of my findings on 3 different respondents was 50 pages. A very informal review of some of the recent school board code of conduct investigations out there range from 20 pages to 50 pages, fact-finding investigations of 1 trustee. Thus, I submit that the global report before you of 50 pages reviewing the conduct of 3 trustees is not excessively long. Further, the findings report specific to each trustee named as respondent in the complaints are 8 pages, 5 pages, and 14 pages respectively. The bulk of the package before you is made up of appendices. Why did I include them? Because you are the decision maker. I have reviewed the facts. I have made recommendations, and I wanted to give you as much information as I could so that you could make an informed decision. Ordinarily, as Integrity Commissioner at the Municipal Council level, with different statutory, which has a different statutory scheme, I don't include all of the appendices. I don't need to, because there is a different statutory regime, because my statutory role is different. Rather than summarize the respondents' replies with this complaint, I've given you the replies to the original complaint and the draft reports directly to you. A little bit about confidentiality. In reporting to the board, I've maintained the confidentiality of the complainants, disclosing particulars except the identity of the complainants. The code does not require the Integrity Commissioner to advise the respondent of the complainant's identity, providing only, and I quote, "the respondent shall receive details of the allegation and have an opportunity to respond." I interpret this section to mean that when I carry out my investigation and request to speak to individuals, I will do so maintaining confidentiality. This is clear in the letter of the code rules and in my communication with individuals subject of the complaint. It is my duty to maintain confidentiality in my correspondence between complainants and respondents on all matters connected to an investigation until I arrive at a finding recommendation, and I disclose details and identities only necessary for the purpose of making a fulsome report. I include in my correspondence with the individuals, when I write to individuals for meetings or notice of a complaint or request for information, that I explain that they are to ensure confidentiality, and to not adhere to the requirement of confidentiality will undermine the integrity of the very process that I'm following. Mediation. Trustee Kaplan-Murth expressed that she would be willing to mediate the complaints. However, having conducted an initial review of the responses to complaint 1, supporting documentation, and having spoken with the complainant and each of the respondents, I decided that the circumstance of these complaints were not conducive to an informal resolution. I made the discretionary decision to proceed to formal resolution pursuant to section 4.15 of the code. It should be noted that Trustee Kaplan-Murth had advised that she would be willing to participate in mediation if the other respondents would do so. While it is the Integrity Commissioner who ultimately determines whether a complaint is managed through the informal review process or the formal review process, I do consider the submissions of the respondents and the complainants to determine if mediation will be conducted. In Trustee Kaplan-Murth's reply to the complaint, she advised, and I quote, and it's in the report, but I will read it here, "I am not very hopeful that any form of mediation will reduce the toxicity within the board, given how ingrained it is in the history of the board. It's inappropriate to scapegoat me for this dysfunction. I am nevertheless willing to engage in good faith with my colleagues in a communal process of mediation if we are all involved. It cannot single me out." She goes on to say both Trustee Blackburn and Dixon expressed that sadly, given the pattern, there must be an assurance that it is psychologically and physically safe to engage in such a process. I communicated to both Trustee Blackburn and Dixon about the opportunity for mediation, but it led me to a decision that the issues raised in the complaints could not be mediated at the time of the receipt of the complaints because the trustees had entrenched positions. To be clear, it was considered. I did not deny it. There were other issues to consider, and I determined that for all 3 trustees concerned to feel safe, there was an there wasn't an atmosphere conducive to mediation. That's not to say that the bigger issues at play with respect to the dysfunction and breakdown in communication that Trustee Kaplan-Murphy speaks of and that I have witnessed, and the lack of trust among board members may not warrant mediation, just not with respect to this particular complaint. I'm going to stop here with my overview, and I will allow you to provide me with questions that you may have on the process or any clarification you may need at this time. Thank you, Chair.
Thank you very much, Ms. Craig, for your report. So I ask trustees, are there any questions with regard to process or for clarification? Trustee Lyra.
Thank you. So just to seek absolute crystal clarity, your report says that following the receipt of the Integrity Commissioner's fact-finding report and findings reports, the Board of Trustees considers her reports along with the responses of the respondent, and the Board of Trustees accepts or rejects the finding and decides whether respondents have contravened the code and whether to impose sanctions. So you are saying in your report and in statute that we must make a decision based on the facts that you have provided in this report. Do I have all of that crystal clear?
Through the chair. Yes, correct.
Okay, that was it. Thank you.
Are there any other questions for Ms. Craig? And I am seeing no further questions. So that brings us to the matter of determination of breach. We have heard our Integrity Commissioner's report and now turn to consideration of her recommendations with respect to whether any of the three respondents breached policy P.073.gov Board Member Code of Conduct. In our deliberations, I remind trustees that section 4.33 of that policy states the board shall vote on the decision and sanction on the basis of the facts determined by the Integrity Commissioner in the final report. And I place emphasis on the phrase, on the basis of the facts determined by the Integrity Commissioner in the final report. This means that the board should not consider any facts other than those set out in the Integrity Commissioner's final report. The respondents all had the opportunity to review and comment on the report before the final version was prepared and submitted, and their comments have been included in her report. If a motion is put forward regarding any one of the three respondents, we will make our decision as to whether there was a breach. And if the decision is yes, we will then entertain a motion regarding sanctions for that respondent before dealing with any motions on breach possibly committed by the other respondents. The respondent who is named in the motion that is on the floor may be present during our deliberations, but shall not participate in the deliberations, shall not be required to answer any questions, and shall not vote on a resolution to determine whether or not there was a breach or on the imposition of sanctions. The complainant or complainants may vote on a resolution to determine whether or not there was a breach and on the imposition of a sanction. Staff and legal counsel are in attendance to assist the board in understanding whether or not there was a breach, in understanding our administrative and legislative responsibilities as necessary. So are there any questions before we proceed? I've started a speakers list. But I believe that Ms. Giroux has a few comments to contribute before we go to our first speaker.
Thank you, Madam Chair. I think that the Integrity Commissioner has captured most of what was in my notes and in your notes as well. And just a reminder that the board makes the decisions based on the facts in the report, and that excuse me, The board must, the report recommends a breach decision in one case. The board must consider that recommendation and pass a motion to confirm a determination of a breach. It is not necessary to pass a motion with respect to the respondents where the integrity commissioner did not find a breach. However, it is possible for a trustee to move a motion with respect to one of those respondents if they do not, based on the findings in the report, do not feel that the recommendation of the integrity commissioner is sufficient and they believe there is evidence of a breach. So just want to make sure people have that procedural knowledge before you go forward.
Thank you very much, Ms. Giroux. And I will now go to trustee Milburn.
Thank you, Madam Chair. I would like to move the recommendation. I will give the manager a few moments to get it up on the screen. Upon review of the facts as documented in the Integrity Commissioner's final report dated December 15th, 2023, regarding a code of conduct complaint in relation to trustee Kaplan Mirth, the board finds that trustee Kaplan Mirth has breached sections 3.5, 3.7, 3.8, 3.15, 3.17, and 3.18 of policy P.073 Board Member Code of Conduct. All right. I am disappointed that we are back at another code of conduct investigation. Each trustee around this table approved and signed this new code of conduct 7 months ago in May. I want to thank the Integrity Commissioner for her extensive investigation. I think having an independent third party do the investigation is a better overall process for everyone involved. I am very disappointed in the conclusion. I feel that there are inconsistencies with the standards that trustees are held to. I also think the level of respect that I want for this board and the requirements to follow the code of conduct is higher than what this report concludes. I called on my colleagues once before and myself, and I'm going to do it once again. We all need to do some self-reflection on how we are here again and how we can commit to doing better for this board, our staff, and our community. This investigation and this report are not a win for anyone sitting at this table. Most importantly, to our community, I am truly sorry we are here once again. I do encourage everyone listening and in our community to read this report. We are here tonight to vote on the breach that was determined through this process that each trustee in this room approved and signed off on. This report determined that trustee Kaplan Mirth breached the code of conduct. That is what we are here to discuss tonight. I want to conclude by reading the definition of respect that our code of conduct outlines. Respect means honoring oneself and others through words, actions, supporting diversity of beliefs, and treating the world and everything in it with dignity. I will be holding myself to this level of respect, and I am pleading with each colleague around this table to do the same. We collectively can do better. Thank you.
Thank you, trustee Kaplan Mirth. So we have a motion thank you, trustee Milburn. We have a motion regarding trustee Kaplan Mirth, which has been moved by trustee Milburn, seconded by trustee Lyra. And in the debate and deliberations on this particular motion, trustee Kaplan Mirth, as the subject of the motion, will not be allowed to speak or participate in the deliberations. And will not be allowed to vote on the final decision on the recommendation before us. So the floor is open for debate. Are there any trustees who wish to speak to the motion? Trustee Lyra?
Thank you. So I appreciate a lot of what trustee Milburn has said. I think that we as trustees need to hold ourselves collectively accountable for our behavior. I'm very grateful that we made the decision to hire an integrity commissioner. I think the process that we had before, having the chair run the informal code of conduct process and try mediation, was not nearly so successful as involving a third party. I'm going to be voting in support of the motion. You probably guessed that because I seconded it. But I also wish we were not here yet again. I would encourage all of my colleagues to remember that this is public office. We hold positions of public trust, and we need to hold ourselves to account. That's all. Thank you.
Thank you. Are there any other speakers to the motion that's before us? Trustee Jenkins?
Thank you, Chair Scott, and thank you to the Integrity Commissioner for a very fulsome report. I too am very sorry that we are here today having this discussion, and thank you, Trustee Milburn, for your providing your thoughts on how we are to behave as trustees, and I will uphold your views. I fully accept the findings that were prepared by the Integrity Commission, and I will be supporting the motion that presented by Trustee Milburn and seconded by Trustee Lyra.
And are there any other speakers to the motion? Student Trustee Hong.
Thank you. I wanted to also say that I, on behalf of both of us, we appreciate the findings and the work put into the report from Integrity Commissioner Craig. And I really appreciated Trustee Milburn's comments on respect and what standard that the board holds itself up to. This code of conduct review is more about accountability, if anything, about what standard of, that the Board of Trustees holds itself to. And I implore the board to consider the responsibility we have to students and recognize that this is our focus deviating from what it should be focused on. 78,000 students depend on the governance of this board, and by not holding ourselves accountable, we open the door to bad governance and being bad community leaders. So, thank you.
Thank you. Any other speakers to the motion? Seeing none, I will go back to you, Trustee Milburn, for wrap up.
No wrap up is required.
In that case, Manager Guthrie, could you please open the vote in eScribe on the motion to find that Trustee Kaplan-Myrth has breached the code of conduct? Trustees will please note that approval of this motion will require an affirmative vote by at least 2/3 of the elected members of the board. That is at least 8 of the 11 trustees eligible to vote on the motion. Under the rules in policy P.073.gov, abstentions are the equivalent of negative votes. The vote is now open, I believe. And we have a result. The motion is carried 11 in favor, none opposed, and no abstentions. Moving on, then, having found that trustee Kaplan Mirth breached the code of conduct, the board may now consider imposing sanctions. Under the board member code of conduct policy, as noted previously, the sanctions available are censure of the board member, barring the member from attending all or part of a meeting of the board or a meeting of the committee of the board, or barring the board member from sitting on one or more committees of the board for the period of time specified by the board under our policy not to exceed 6 months. The board cannot impose a sanction that is more onerous than the 3 just specified, but it may impose one that is less onerous, such as a warning or a requirement that the board member successfully complete specified professional development at the expense of the board or other similar sanctions. The floor is open, and I recognize trustee Milburn.
I will wait for the manager to. Thank you. That in accordance with sections 4.41B of policy P.073 Gov, trustee Kaplan Mirth be barred from attending the next regular board meeting dated January 30th, 2023, and that in accordance with section 4.41C, 2024, and that in accordance with section 4.41C of policy P.073.gov, trustee Kaplan Mirth be barred from sitting on the following committees of the board for a 6-month period beginning January 1st, 2024 to June 30th, 2024 inclusive. Committee of the Whole Budget, Ad Hoc Policy Review Committee, Advocacy Strategy Committee, and Advisory Committee on Equity.
And is there a seconder for this motion? Trustee Dixon, thank you. Discussion on the motion. Trustee Lyra.
So first I have a question, and that is, you're gonna have to jog my memory. I believe all of the committees that trustee Kaplan Mirth sits on. Can I get an affirmation? With the exception of SEAC. Okay. So one of the things that I have to consider is if this is, as this is a first time the board has found her in violation, and as we must have some ability to escalate should a future violation of the code of conduct be found, I am concerned about bringing forward what I view to be the maximum possible punishment in stripping her of all of her committees and a board meeting, because that leaves us nowhere to go. If you give the maximum for the first offense, there is no possible escalation. And so for consideration, if somebody else wants to move it, they can, but I'd like people to consider, I saw at least one other hand, striking Committee of the Whole and Committee of the Whole Budget. That leaves the opportunity in the future, should there be future violations of the Code of Conduct, for trustee Kaplan Mirth to have things she may value that would be taken away in future violations. And so I'm not going to move it because I'd like to hear from some of my colleagues, but I think it is worth considering whether or not we want to issue the maximum possible sanction for a first offense.
Before I go on to the next speaker on my list, I'm just going to ask staff in terms of comment, in terms of whether there are additional sanctions that could be applied, or what happens if there would be further incidents. Mr. Director or Ms. Giroux?
Madam Chair, the first thing I would say is I do not believe that this list is the full list of committees that the trustee sits on. I believe the trustee is also a member of the Special Education Advisory Committee. I'm looking to the manager to confirm that. So I just wanted to make sure that people were aware of that, and I don't know if that was the mover's intent. And the second question, I'm sorry, I missed the crux of the question.
If there were a new incident, what would happen?
Well, the board has the capacity to extend the length of the sanctions. It also has some additional capacity in terms of censure, can make a statement of censure, express concern. And have to think about this a little bit more, but the board could, if it extended the time, that could include a longer time period which precluded appointments at a subsequent organizational meeting, as an example.
And we could bar from it for an additional meeting of the board if we
Exactly.
had that as
And,
well.
and sorry, there was just some question here. This motion is written for 6 months, but I think the question was around if there was subsequent breaches that were to be addressed, then you could extend the time period.
So the time period could be extended, and if there was a new breach, that could also mean the imposition of a one meeting, barring from one meeting, and the possibility of censure. So does that answer any questions that were in your mind, trustee Lyra, or was that what you intended to ask?
I think it has spawned more questions. My understanding is that we can impose for any given violation of the code of conduct up to one board meeting and removal from any number of committees for up to 6 months. So if there is a future violation of the code of conduct, we don't get to say 6 months, like these 6 months have not yet elapsed. We can add 6 months to the end of it, but we cannot go 6 months plus 3 months because the last one had 6 months. We can't go longer than 6 months is what I'm saying.
That is correct, but it would be a separate motion. And so in that motion, you would contemplate a timeline. So since we're talking about an imaginary scenario, depending on the timing of the scenario, that would determine the timing of the motion. So if it overlapped with this timeline, then you could build into the future.
I will reiterate my concern about giving the maximum, which is 6 months and one board meeting for a first offense. That's all.
Thank you. And I have trustee Blackburn next, and then trustee Aziz, and I don't recall seeing any other hands on this. Trustee Blackburn? And trustee Bell.
Thank you, Madam Chair. Through you, I have a question of clarification and just want to clarify what the mover intends. So it says trustee Kaplan Mirth be barred from sitting on the following committees. So for instance, I don't sit on the advisory committee on equity, but I'm allowed to attend it, go to it anytime I want. I don't have to sit on a committee to attend a committee. So presumably trustee Kaplan Mirth could attend the advisory committee on equity, any of these as a non-sitting member. Like I'm not on the advocacy strategy committee, but I can go. Do you understand what I'm getting at? The question I'm asking?
And that is that all trustees can attend and participate who are not named as members of the committee. But clarification as to what not sitting on the committee would mean in terms of ability to attend or participate, Ms. Giroux?
The issue is contemplated in section 4.44 of the policy. And so essentially, the board can't bar a member from attending a meeting that's open to the public. But a member who is barred from participating in the meeting is not entitled to receive any of the materials that relate to that meeting or part of the meeting that would not be available to members of the public. So if the agenda is posted on the website, the trustee could access it that way. But any communication that goes to members of the committee would not go to that member during the period.
Anything further, trustee Blackburn?
That is all. Thank you, Madam Chair.
Thank you. Trustee Aziz?
Thank you. Thank you, Chair. Through you, I have one question and then a proposed amendment to the motion on the screen. My first question is in regards to what the Integrity Commissioner Craig has presented on page 185 of her report. Under her recommendations to receive the findings and then to impose sanctions, she lists some considerations for the board. And I'm wondering if staff or the chair could elaborate on whether or not the board is engaging with the considerations to explore, including a human rights specialist to support trustees and update our safety policies, so on and so forth.
And could you please just repeat the page that you're referring to?
Absolutely. On the page itself, it says page 185, but on the document reader, it says 188. It's okay, it's the exact last page. Oh, that's a good point. It's literally the last page. Go all the way to the end.
Yes, and these supplementary recommendations would be dealt with separately from the motions around breach and sanctioned. And if trustees wish, I would ask if Executive Officer Giroux could comment at this time.
Absolutely, Madam Chair, through you. The policy for the Code of Conduct in section 4.60 provides the Integrity Commissioner with the authority to recommend restorative actions. And there's a range of issues there. My recommendation to the board would be that those restorative actions be left with the chair in consultation with the director. Some of those issues, our work is currently underway on them, and they've been addressed in the board's work plan and areas of focus and other conversations. So I don't think a motion is required. Certainly, when you look at the policy doesn't contemplate them in terms of the decision-making process, but rather the guidance that can be provided through the Integrity Commissioner's office.
Thank you, Executive Officer Giroux. I just appreciate that update because would appreciate updates on some of these issues probably in camera with regards to safety measures and so forth. I think those are important going forward.
Absolutely, that can be done.
Thank you, Chair. And if I may move an amendment to the second part of the motion to reduce the 6-month period to a 3-month period. So then it says beginning 1 January 2024 to 30 March 2024. Please and thank you.
So the amendment has been moved to make it a 3-month period beginning 1 January 2024 to 30 March 2024. Is there a seconder for that amendment? Trustee Presley will second that. Any further introduction, Trustee Aziz?
Very briefly, I'd like to echo concerns I've heard around the table with regards to any further code of conduct complaints in which we've already exercised what is almost the maximum penalty for a code of conduct in terms of a 6-month bar from committees and a barring from a board meeting, as this is the first time this board has found Trustee Kaplan-Murth in violation of the code. I think this would be an appropriate opportunity to express opportunities for growth. And as per the chair's comments on engaging in mediation efforts, as per Integrity Commissioner Craig's recommendations or considerations at the end of the report for conciliatory effort, I think moving forward in a reconciliation approach as opposed to a punitive approach could provide us with opportunity to grow and build as a board, as opposed to punishing one another for the errors of the past, and build on what Trustee Milburn said earlier on building respect and communication amongst one another. Thank you.
Thank you. I know that Trustee Bell had her hand up for the main speaking list. Did you also have your hand up for this amendment? Not for the amendment, so I'll keep you on the main speaking list and go then to Trustee Blackburn and then Trustee Presley.
Thank you, Madam Chair. And through you, I will be supporting this amendment, and I thank Trustee Aziz for bringing it forward. I am a firm believer that people have the capacity for positive change. And I believe that's in all of us. I really look forward to a new year in which we can build trust amongst ourselves, where we can be laser focused on student achievement and staff and student well-being. And I think this amendment may help towards that goal. So I am prepared and I will support it. Thank you, Madam Chair.
Thank you. Trustee Presley?
Thank you, Madam Chair, and through you, I would like to echo the sentiments of both of my colleagues, Trustee Blackburn and Trustee Aziz. I too believe that we can all come together with a focus to support the students of our board and our strategic direction. I also supported the amendment as I felt that there might be a large impact to the constituents of Trustee Kaplan-Murth, and I want to ensure that her constituents are represented as best as possible while we look towards restorative actions. Thank you.
The amendment. And I have Trustee Lyra as a second-time speaker, but as first-time speakers, I will go, or no, sorry, you're not a second-time speaker on the amendment. So on the amendment.
I will not be supporting this amendment. I too am a believer in that people can change over time and get better over time. My preferred fix would be removing fewer committees, not lengthening the period of time from which someone is barred from almost all of the committees. And so, given that I think there is a better fix possible, I'll be voting against this amendment.
Thank you. And I would have next on the amendment comment from student trustee Emma Hong.
Oops. Through you, Chair. On behalf of both of us, we'd be in support of the amendment. We agree with a lot of the sentiments echoed by the rest of the board. By barring such a long absence at the board table, it would cause a lot of loss of very valuable perspectives.
And I also have a student trustee Malika Kamanzi.
Sorry. Yeah, and also like through you, Chair. Oh, and about that, I have a question or maybe even a concern. During these 3 months, where Trustee Kaplan-Murth will be barred from sitting at the board, how are we going to make sure that her constituents still feel heard and still have a representative? Because I'm guessing that she will not be able to participate as actively as a member of the board, but she still represents a whole zone.
Even when barred from committees, she would still have the right to attend and participate fully at board meetings. Our committees do send any recommendations for actions, ultimately come to the board for decisions. So she would have an opportunity to provide her views there herself. She also, I'm sure, if she had significant suggestions to make, could see if one of her colleagues would be willing to put those forward on her behalf, even though she is not herself she herself would not be able to attend and participate in the committee meeting. I'm quite sure that there would still be many ways in which she could represent the people in her zone.
Thank you, Chair.
And thank you. Other speakers to the amendment? Seeing none, back to you, Trustee Aziz, for wrap up.
Apologies, my computer froze and I almost cried. I think this is an opportunity for reconciliation. I think this is an opportunity to also look to our chair and staff for leadership on the mediation efforts as presented by Integrity Commissioner Craig on the last page of this report, because this is in large part with regards to the conduct of a trustee and our ability to reconcile with, human rights issues that affect our ability to function as a board. And of course, want to echo the comments made by Trustee Milburn and her opening statements on this motion, in encouraging us to reflect on our role as representatives of the public. And I encourage my colleagues to support this motion or amendment to the motion. Thank you.
Thank you, Trustee Aziz. And since this is an amendment, this will be a show of hands vote unless otherwise requested. So all those in favor of the amendment that's on the screen to change to a 3-month period. And those opposed? Trustee Bell, is your hand up for the vote or not?
No, I voted in favor with my real hand.
You voted in favor and I missed your physical hand. So the motion, the amendment carries 6 in favor, 5 opposed. And we move on to the next speaker on our list, who is Trustee Bell.
Thank you very much, and through you, Chair. Can you hear me? Can I get a thumbs up? Yes.
We can at the moment, but you tend to fade in and out. So please try to stay fully in voice.
Okay, so based on the facts of the Integrity Commissioner, I have determined that all 3 respondents have violated the code. In particular, this is important to the sanctions and what I'm about to speak to. In particular, board members shall discharge their duties in a manner that will inspire public confidence in the abilities and the integrity of the board. I will not be supporting any sanctions for Trustee Kaplan-Myrth for a number of reasons. In the report, it clearly states that she has been living with traumatic events consistently for months.
Trustee Bell, we are speaking specifically to the motion about Trustee Kaplan-Myrth, not about the situation in general.
That's what this is a part of it. I believe that is a component of why I will not be supporting the sanctions for Trustee Kaplan-Myrth. Number 1, the reason why I will not be voting in favor of the sanctions is because Trustee Kaplan-Myrth has been living with traumatic experiences for months upon months, and that would no doubt alter your state and your ability. Number 2, I do not believe that the sanctions are appropriately commensurate to what has been outlined in the facts. I also do not believe that these sanctions will change any behavior. What they end up doing, as rightly said by our student trustee, is they hurt her community and they hurt her as a representative, they hurt her constituents. I do, however, I am, however, firmly in support of the recommendation, and I myself have recommended it time and time again, that a mediator be brought in to help all of the trustees to get rid of the dysfunction and the distrust that is present in our board that we see throughout this report. And I also support the recommendation by Suzanne Craig to bring in a human rights specialist, because when you are living in a traumatic state for months upon months upon months, that will definitely affect your mental health and well-being. And for that reason, I will not be supporting any sanctions.
Thank you, Trustee Bell. And are there any other speakers to the motion on sanctions as amended? And I'm seeing none, so back to you, Trustee Milburn, for wrap up.
No conclusion required. Thank you.
In that case, I will ask Manager Guthrie to please open the vote in eScribe on the motion to impose sanctions on trustee Kaplan Mirth. And again, trustees, please note that approval of this will require a vote of at least 2/3 of the elected members of the board.
Uh,
And we have a result for the vote. The motion is carried, 10 in favor, 1 opposed, no abstentions, and that is of 11 voting. Are there any other motions with regard to the report from the Integrity Commissioner and its accompanying recommendations? Trustee Lyra.
I do, but I would ask for 2 minutes so that I can make sure I have the wording correct.
I will call a 5-minute recess. And I would like to call this meeting back to order. We have the next speaker on my speakers list is trustee Lyra. Please go ahead when you're ready.
Can we give a moment for Manager Guthrie to get the text on the screen? So I would like to move the following recommendation. Sorry, the following, well, it's not a recommendation, motion. We'd need a seconder. Sure. Upon review of the facts, as I am speaking into my mic. Okay. Upon review of the facts as documented in the Integrity Commissioner's final report dated 15th of December 2023 regarding a code of conduct complaint in relation to trustee Blackburn, the board finds that trustee Blackburn has breached sections 3.7, 3.15, and 3.18 of policy P.073.gov, board member code of conduct, for misleading staff in such a way as to impede their ability to fulfill the duties of their job, and that trustee Blackburn has breached sections 3.29 and 3.3 of policy P.073.gov, board member code of conduct, for giving media interviews in contravention of sections 3.1 of policy P.136.com.
Thank you. Is there a seconder for this motion? Trustee Milburn will second that. Go ahead with your introduction, please.
All right. A little more than 1 year ago, we had our first code of conduct training as a new board of trustees. In it, we learned that the code of conduct should not be a weapon to be wielded, but a set of parameters to define the behavioral expectations of trustees. Our votes tonight are how we set those expectations. As a code of conduct, absent enforcement isn't worth the paper it's written on. Before us, we have a report with recommendations. On page 24, and reiterated by Ms. Craig earlier tonight, it specifically says, the Board of Trustees accepts or rejects the findings and decides whether the respondents have contravened the code and whether or not to impose sanctions. On page 160, an incident is described which troubles me. I believe, based on the facts presented in the report, that the described incident contravenes sections 3.07, 3.15, and 3.17. Trustee Blackburn knowingly provided false information to staff in such a way as to impede their ability to fulfill the duties of their job. As outlined in the report, staff were trying to remove the public, and Trustee Blackburn muddied the waters about who was allowed to be present and who needed to go. I appreciate that the report says this was not intentional, that it was an accident. However, trustees cannot be judged solely on their intent. No one ever intends to hit a parked car while driving, but one who does so is still held accountable for that mistake. We should not set a precedent that a trustee can spread misinformation to staff and in doing so impede their ability to do their job, regardless of their intent. 3.07. Trustees, as leaders of the board, must uphold the dignity of the office and conduct themselves in a professional manner, especially while representing the board, attending board meetings, or while on board property. Spreading misinformation to staff is not conducting oneself in a professional manner, especially while on board property. 3.15 says board members shall not engage in conduct that would discredit or compromise the integrity of the district during meetings of the board or at any other time. Spreading misinformation to staff in such a way as to impede their duties compromises the integrity of the district and the board. And 3.17, all board members have a duty to treat members of the public, one another, students, and staff members respectfully and without abuse, bullying, or intimidation, and to ensure that the work environment is free from discrimination and harassment. Spreading misinformation, making one's job more difficult, is not acting respectfully. There is a second clause to this motion, violations of sections 1.29 and 1.30. This report does talk a great deal about charter rights, specifically the freedom of expression. A court case recently made the news, finding it was legal to give the finger and curse out a police officer. And while it may be legal, technically legal is the very lowest bar for behavior. We have the ability to set a higher bar for trustees, for ourselves. We can set expectations of ourselves and future trustees with the appropriate nature of our conduct. If we set the precedent that either of these behaviors are acceptable, I do not believe we are upholding the characteristics we try to empower our students with. As adults, we should be held to a higher standard than we hold our students. And as elected officials, we should hold ourselves to the highest standard possible. For those reasons, I would ask everyone to support finding a breach. Thank you.
Thank you, trustee Lyra. And again, for the deliberations on this particular motion, trustee Blackburn may not, as the subject of the motion, may not participate in our deliberations and may not vote on the motion. Are there speakers to the motion? Trustee Milburn.
Thank you, Madam Chair. As I previously stated, I am disappointed in the conclusion of this report, although I want to thank again the Integrity Commissioner for an extensive investigation. I really believe that the level of respect I want for the board and the requirements to follow the code of conduct is higher than what the report concludes. And I really am going to implore that if we all want to do better, we have to hold ourselves to a higher standard. I will be supporting this breach of code of conduct this evening because of that. Thank you.
Other speakers to the motion? Trustee Aziz.
Thank you, Chair, and through you. After just a year and some as a trustee, along with many of the new trustees sitting at this board table, it is surprising, perhaps, that we have seen 2 code of conduct complaints come before us. And as such, I think it is important that we continue to hold ourselves and each other accountable as those who are holding public office, some for the first time. And if we are going to find others in breach of our code of conduct, based on their actions and words, regardless of intent, we need to hold others to that same account. Based on the findings in the report, based on our experiences at the table, I will be supporting the motion on the floor. Thank you.
And are there any other speakers to this motion? Trustee Bell.
My question is for the mover. Could you please point us to where in the document it outlines that trustee Blackburn misled staff? And if there are other facts related to how and why that happened, that could be spoken to, that would be appreciated within the facts. Thanks.
Trustee Bell, the allegations referred to and the comments by the Integrity Commissioner are on page 160 of the report, which is dealing with the question, did trustee Blackburn violate the code by virtue of her conduct or statements immediately following the September 11th meeting, including in her interactions with media present following the meeting? And the following paragraphs on page 160 describe the two parts of the incident.
Thank you, Chair. Would it be possible, instead of scrolling rapidly and trying to read, if that it could be outlined what in fact, how it was that trustee Blackburn misled staff? If that could be spoken to, that I would very much appreciate that, because I don't have the page number coming up as quickly as I would like. Thank you.
Would it be possible to have a summary of that? I think not by any of us sitting at the table, because of potentially misrepresenting what it was that the Integrity Commissioner said in that section.
Madam Chair, the Integrity Commissioner is on the line, and I'm sure she can speak to the findings in her report.
That would be excellent. Thank you very much. Ms. Gregg?
Through you, Madam Chair. So I'm just going to say a couple of comments before I look at page 160. The Integrity Commissioner is a fact finder, and as I mentioned in my opening statements, I don't disclose in the report all information that I have received, but I rely on all information that I receive to make my findings a fact. I did speak with 19 witnesses. I did speak with other individuals. And as I look at page 160, I can clearly state that the incident where after the special board meeting on September the 11th, Trustee Kaplan-Murth, Trustee Blackburn, and others were walking to an area where there were individuals and also journalists. Trustee Blackburn was not following Trustee Kaplan-Murth. And at a point when Trustee Kaplan-Murth reached the area where there were reporters, she turned and she uttered to Trustee Blackburn and to other individuals, get out, out, out. There were staff there when Trustee Blackburn stated, this is my media advisor, referring to Chantal Fowl. She was not disobeying staff or trying to in any way mislead staff, but rather she was trying to get Trustee Kaplan-Murth to not demand that this individual leave a space that was a public space. I don't have any findings that identify, having spoken to individuals, that any staff were of the belief that this individual, to which Trustee Blackburn said is my media advisor, and she did say in her statement to me that she has no relationship, and this was only she was caught off guard, and she made this statement, which was not a truthful statement, but made this statement so that this individual could be shielded from Trustee Kaplan-Murth's demanding she leave, and not in any way disobeying staff. Those are my comments.
Thank you,
Trustee Bell. I'm just wondering, within the report, does it state that staff were trying to clear that room at the time to only media? Was that part of the fact finding? That's a follow-up question. Thanks.
Through you, Madam Chair, to Trustee Bell. I'm sorry, there's echo. Should I stop? It is a complex scenario, but there was no dedicated space that was only for Trustee Kaplan-Murth. I can't say too much because there was a safe space that was designated for her. We will leave it at that. But the space that both Trustee Blackburn, Trustee Kaplan-Murth, and this individual were going to was a space where media was going to be. And it was a space where media and others were allowed to group for interviews. It was Trustee Kaplan-Murth who wanted it to be exclusively for her use, for her safety and concern. And staff was not trying to secure the room. Staff, from the information that I received, was just trying to maintain order. Thank you.
Trustee Bell.
Okay, so from what I've heard from Suzanne Krieg, the staff were not trying to clear the public from that room, that everyone was able to stay there.
That was through you, Madam Chair. That was my understanding of the information I received. Staff were trying to ensure that there was safety amongst those who were there because there was an altercation and there was shouting.
Anything further, Trustee Bell?
I think shouting on the part of Trustee Blackburn out of frustration or whatever it may be, and the shouting on the part of Nili Kaplan-Murth does not provoke public confidence in our board, nor does it demonstrate that they have acted in a professional manner, which is also one of the code findings. I think that both of them should be held to the same account when it comes to this intervention. So I thank the Integrity Commissioner for her responses. And I also hope that my colleagues will hold all trustees to the same account. Thank you.
Ms. Craig, you had further comment?
I just have one comment through you, Madam Chair. I did not find that Trustee Blackburn was shouting at this time.
If that is in fact in response to what I have just said in the report, it said something towards the effect of her actions were a result of frustration. That's what I read in the facts.
Her actions of not moving and wanting to stay in the room.
Thank you. I think that we should move on to the next speaker here. And that would be Trustee Kaplan-Meier.
Thank you. Through you, Chair. I was actually raising my hand just to ask if it matters that that in fact it was my husband who asked the staff to clear people out of the atrium because I was unsafe. And also whether it matters that there was no specific place I was told to be after that meeting. And also if it matters that the person who was in a situation where I was anyway, it doesn't matter. What I was going to ask is that the Integrity Commissioner seems to very differently respond to Trustee Blackburn's comments, and I'm wondering whether the Integrity Commissioner would like to elaborate on why she thinks it's okay to call a Jewish woman white when you wouldn't call any other minority, whether our skin is white, brown, or any other color, just a white woman to dismiss racism. So if the Integrity Commissioner could please elaborate on why it's okay for Donna Blackburn to have said that.
Trustee Kaplan-Meier, I don't believe that question goes to the motion that is before us, which relates specifically to Trustee Blackburn's possible actions with regard to misleading staff in such a way as to impede their ability to fulfill the duties of their job. And in the second part, for giving media interviews in contravention of a section of our policy on communications.
Okay, so I apologize then. I guess with respect to the Integrity Commissioner's finding that she thinks that it isn't a big deal that Donna Blackburn told the public that Chanel Fall is her media advisor. I guess my question is when we're thinking about whether something is harm is intentional or not, and knowing that that is a person who has been actually actively, intentionally targeting me with some of the very vitriol.
Trustee Kaplan-Meier, I will stop you there.
Okay.
Our decision making this evening is based on the report that we have received, which I think is.
So I'm asking the
really
Integrity
clear.
Commissioner. That's what I'm asking the Integrity Commissioner then perhaps to clarify why she doesn't think that is significant.
To comment further on why she did not recommend that we find Trustee Blackburn in breach. Is that what you're asking?
Yeah, that's a good way of putting it. Thank you.
In that case, I will allow a response.
Thank you, Madam Chair. Through you, there were a couple of questions there, and I'd like to give thoughtful responses to all of them. So I think the term that was used was the Integrity Commissioner thought it wasn't a big deal. I take issue with that because I have certainly taken seriously all of the allegations and looked at all of the information. I will not in any way put myself forward as an expert in human rights, although I have some knowledge of human rights. And in fact, I put in my report some language around intersectionality. And having spoken to Trustee Blackburn, who looking at Trustee Kaplan-Murth's response to the draft report, objected to Trustee Blackburn referring to her whiteness as, and I'm going to paraphrase, white privilege, and she is a Jewish woman, and that is entirely your truth. I did not state in my report that Trustee Blackburn saying this was not a big deal. I recognized that that you were very much offended by this. And in fact, it is for this reason that I believe that there is a need for a human rights specialist to speak to all of the trustees about what speech is acceptable, because looking at intersectionality and looking at individuals who have intersecting identities of whiteness, of Jewishness, of Blackness, of gender identity that may not be visible to an individual. And it is not okay for someone to not accept and realize that, but it is also a recognition that work has to be done at the board. With reference to the individual Chantal Fowl, my understanding is from speaking with individuals, again, I must be careful not to identify, however, individuals responsible for security and safety that evening, that individuals who were allowed into the board were allowed into the board facilities based on a recognition that there were individuals who should not be in the board. And therefore, the conclusion is that those who were not stopped from entering, those who were not in any way held, were allowed entry because based on the information that those responsible for the safety had, the individual was not, should not have been denied entry. And thus, your reality, Trustee Kaplan-Murth, and the concerns with this individual are your truth. But based on my investigation, the individual who was there, journalist or not, was allowed to be there.
Trustee Kaplan-Murth.
Sorry, thank you. Through you, Chair. I guess I would say that the person who is actually the target of threats, identifying a person who is the threat, one of the threats to her, isn't just that person's opinion or their reality at that moment. It's fact, it's truth. And if it were that anybody else were a target, I think that there would be no question that it would have seemed inappropriate to allow somebody who is targeting and threatening that individual to remain. So anyway, I thank the Integrity Commissioner for her response, but I think it only highlights what I'm saying.
Is that everything, Trustee Kaplan-Murth?
Well, I will support the determination of breach for Trustee Blackburn. I agree with the motion that's put forward.
Thank you. Are there any other speakers to this motion? Trustee Aziz.
In advance of voting on this motion, I would like to again reiterate that if we are going to hold Trustee Kaplan-Murth accountable for her words and actions in the previous vote, we must hold all of our trustees to the same account. We cannot hold different standards for those regardless of their intention, and I appreciate the Integrity Commissioner's highlighting that, one trustee may have acted one way out of frustration and another might have acted out of anger or exhaustion. However, when any of us are upset, as we, so often demonstrate to our students, we must resolve and take account for those words and actions, and then take the appropriate reconciliatory action to amend what has been said and what has been done. So for those reasons, I will be supporting this motion and implore my colleagues to ensure that we hold each other, and I will implore you to hold myself account to the same code of conduct we all signed. Thank you.
Thank you, trustee Aziz. Trustee Lee.
Thank you, Madam Chair. With respect to some comments that have been made by my colleagues, I just want to point out that the Integrity Commissioner is a third party investigator in this matter. And with regards to holding to the same standard, I would argue that having a third party individual investigate all three individuals in the complaints does hold to the same standard, because one person is investigating all the matters from the same perspective. It's not different individuals or different entities investigating or litigating the same, multiple complaints. It is one individual investigating all three. So in my opinion, the same standard is being held.
Thank you, trustee Lee. Trustee Jenkins.
Thank you, Chair. Just for clarification, for the second paragraph, was it determined that the trustee misled staff?
I believe you're asking me, trustee,
Thank you, Ms. Craig.
through the chair, to the trustee. I have no knowledge that staff was referring to this individual to get out of the room, and that trustee Blackburn, in disobedience to staff, misled them and said this was my media advisor. Trustee Blackburn has stated very clearly that this individual is not her media advisor. She has apologized and she has said, the reason I said this sort of in a very spontaneous way is because Trustee Kaplan-Murth was saying to individuals, including herself, including Trustee Blackburn, get out. There was a shared space and she said, get out. And she said, get out forcefully, and she repeated it, understanding it was a very, very difficult situation, understanding the threats and the concerns. I can't understand, but I recognize that that was going on. However, there was an individual trustee who was not told beforehand that that room was dedicated only to Trustee Kaplan-Murth. And there was another individual who was not told that that room was dedicated only to Trustee Kaplan-Murth, and who was allowed into the board building as an individual member of the public and had a right otherwise to be there. So in answer to your question, she is my media advisor was not a correct statement, but it was not towards staff, because staff was not telling everyone that they had to leave. Staff was trying to ensure that the situation was under control because of the heightened concern and escalated tone of Trustee Kaplan-Murth.
Thank you, Ms. Craig.
Anything further, trustee Jenkins? Trustee Presley.
Thank you, Madam Chair, and through you. I by no means wish to put you on the spot, Mr. Director, but I'm wondering if you have a comment you'd be willing to share. No?
I'm sorry, I didn't hear that properly.
I was just wondering if the Director of Staff would be able to provide a comment.
Director?
Through you, Madam Chair, no additional comment from staff beyond what's been reported in the findings.
Trustee Lyra is the mover. She will be getting wrap up, so we will go back to her when we get to that.
I'd like to strike part of the motion. And if you do that in wrap up, nobody else can speak to it once it's changed.
In that case, I will allow it.
I'd like to strike everything between for and job in the second paragraph.
And I'm going to ask for staff comment on whether or not I should be ruling that an amendment or withdrawing of something that would be in order, because if that was the reason for saying that the breach of those three sections had happened, and you take away the reason why you said the breach had happened, then it seems to me that the whole thing should be struck.
May I speak to it?
And I'm just going to ask staff to comment on that.
Well, the comment I was going to make was it's an amendment.
I'm
so
sorry, I can't hear.
It should be presented as an amendment because the motion is on the floor. So anyone else who wanted to amend it would have to move it as an amendment. And I don't know if we have a large enough school of experience to say that every motion of sanction referenced a section and had explanatory text contributing to it. Because short of taking a few minutes to review it, I don't know that 3.7, 1.5, and 1.8 all deal with that specific issue or is an explanation for each of those pieces. So my suggestion to you procedurally is that it be introduced as an amendment, you deal with it as an amendment, it carries or it fails, and then you deal with the main motion.
In that case, I will allow it to be introduced as an amendment. And I will allow trustee Lyra to introduce it.
Thank you. So based on the further information from the Integrity Commissioner, I feel this is best struck. I retain the concerns that I enumerated in 3.7, 3.15, and 3.17 around uttering false statements. And so while it might not have been misleading explicitly staff, they were still not true statements, and trustees should not be uttering untruths. And so for that reason, I would ask that we strike this. My reading of the report was originally that those statements of mistruth had been to staff, which would have been of a misleading nature. Having heard from the Integrity Commissioner, I think it is best that those be struck.
And I will ask if this is a friendly amendment to strike those words. Is there any objection? And I am not seeing any objections, so we will make that change as friendly. Did you have any further amendments?
No further amendments. Thank you.
Thank you. And I will go on to trustee Presley next.
Apologies, Madam Chair, I did not have my hand up.
I'm sorry, I really am having some
Sorry.
difficulty hearing.
Apologies, Madam Chair, through you, I did not have my hand up.
Oh, I thought you had your hand
My
up.
apologies.
And I think we have just about got through everybody who wishes to speak. And I will ask trustee Milburn to take the chair, please.
Chair Scott?
Thank you. Thank you for that. I just wish to speak briefly with regard to the last clause of the motion relating to breaching sections 3.29 and 3.30 of the policy for giving media interviews. I have a question to staff, I guess, and that is whether the right to freedom of expression takes precedence over anything we put in our code of conduct, or whether we can abridge those rights through our code of conduct policy.
Madam Chair, it's not a question we've had a chance to contemplate. And I don't know if General Counsel or if the Integrity Commissioner has any comment. on the broader issue. I guess what I would say to the board is there is a long history and issue with compliance with this section of the policy. And I think you ought to think about compliance with this policy, but I think you also ought to think about what the practice has been and recognize that you have a history there that needs to be contemplated in a much broader context than just this motion.
Chair Scott?
Could we then also please have comment from the Integrity Commissioner?
Through you, Chair Scott. Part of my role, as you all know, is education and learning. And my hope has always been from the first learning session that I had with this board, that the Code of Conduct is seen not as a punitive tool, not as a weapon, but as a way to reset and to allow the board to grow. Very much the sentiments that many of you have expressed tonight. My feeling is that freedom of expression is such a very broad and timely discussion point that what would usually happen at the municipal level is the Integrity Commissioner, following a Code of Conduct complaint where an issue was raised, would, together with the senior leadership responsible for policy and for looking at legal issues, would be consulted to determine if in fact there should be a change to the code, or if the code rules should stand, if there should be commentary, so members of the board are clear as to what they can do, so that their rights are not infringed, but that the legislative parameters of the Education Act are adhered to. So I would recommend, if I'm being asked, that there be a consultation with the responsible staff as it relates to some of these issues of freedom of expression. There are court cases that have opined on this, but there's no clear guidance. And so I would be loath to suggest a change to your code just yet. Thank you.
Thank you, Integrity Commissioner. Chair Scott?
Thank you. I think this gives me pause in terms of supporting this particular motion, because I think there is some lack of clarity around where the intersection is between our policy and the freedom of expression, which certainly has historically been exercised by trustees in this board. In terms of the first section, it is not clear to me that those sections were substantially breached. Thank you.
Thank you, Chair Scott, and back to you.
And we go then to Trustee Lara for wrap up.
All right. Section 3.07. As leaders of the board, we must uphold the dignity of the office, conduct themselves in a professional manner, especially while on board property. Lying is not professional. 3.15, board members shall not engage in conduct that would discredit or compromise the integrity of the board during meetings of the board or at any other time. Spreading misinformation is not upholding the integrity of the district. 3.17, board members have a duty to treat members of the public, one another, students, and staff respectfully without abuse, bullying, intimidation, and to ensure that the work environment is free from discrimination and harassment. Spreading misinformation, uttering falsehoods, does not produce a healthy work environment. I think those three have very clearly been breached based on the information in this report. I would ask that we vote on these separately. I do think that there are two questions in this about whether or not the breach on the first and a breach in the second. And so I would ask the chair that we vote on these separately, because I think there are different questions inherent here. When it comes to our historical free ability to interact with the media, we as a board have had many trustees, including myself, who freely have gone to the media in the past. But if, as the Integrity Commissioner is saying, that we are trying to start anew, we are trying to set a new benchmark, we are trying to say this is what we as a board say should be done moving forwards, this is one of the ways that we can do that. As I said earlier, a code of conduct is not worth the paper it is written on if it is not enforced. And as it stands, it is a breach of the code of conduct, in my opinion. Whether or not that should be changed is a conversation for another time. Whether or not that needs to be updated to be in line with the most current legal changes to freedom of expression, a debate for another time. But the code of conduct, as it was written in September, very clearly has these sections, and they very clearly have been violated. And so I would encourage everyone to support both of these clauses, but I would encourage everyone to support both of these clauses. That's it. Thank you.
Thank you. And we will be voting on the two parts of this motion separately. In the first instance, that trustee Blackburn has breached sections 3.7, 3.15, and 3.18 of policy P.073.gov, board member code of conduct. So that is all that we are dealing with on the first vote, and I will ask Manager Guthrie to set up the vote in eScribe. And Manager Guthrie informs me that there has been a slight glitch and she will be redoing this vote. And we have a result that the vote was 6 in favor, 5 opposed, no abstentions. And therefore, since the vote requires 8 votes in favor to be approved, the motion fails. So now we will hold the vote on the second part of the motion. And again, we have a result on the second part of the motion, which fails. It required 8 affirmative votes to be approved. It has 4 votes in favor and 7 votes opposed. So that does not carry. And given that we have not found a breach, we do not have any sanctions to consider. So my next question is, are there any other motions to be put forward? Trustee Lyra,
Yes,
go ahead.
I have Manager Guthrie can put it on the screen. For much the same reason, in that in September, the policy was written, and I believe it is the correct thing to do. I am going to encourage all of my colleagues to find that giving media interviews, because it was against the written code of conduct, because it was against our written policy in September, that I would ask all of my colleagues to find a breach, and in the interest of time, I'm going to keep it very short.
Is there a seconder for this motion? Trustee Milburn will second. And your introduction?
That was it.
That was it. As speakers to the motion, Trustee Blackburn.
I'd like to call the question, please.
Yeah, I don't think you can move to call to close debate until at least one other person has spoken besides the mover. Trustee Aziz.
I'd like to thank the mover and the seconder for bringing this to us for debate. Just to refresh everyone on the policy referenced for the board member code of conduct p.073.gov that we updated in May 2023. Item 3.30 with regards to upholding decisions and speaking to the media. 3.30 states that, quote, "The chair of the board is the official spokesperson of the board to the public. No other board member shall speak on behalf of the board or represent themselves as a spokesperson for the board unless expressly authorized by the chair of the board. When individual board members express their opinions in the media, they must make it clear they are not speaking on behalf of the board," unquote. For these reasons, I think it's important to consider the comments made to the members of the media by members of the board when expressing their opinion. If they're not explicitly stating that they're speaking on behalf of their own experiences or on their opinion, I'm sure it is understood by the public that they're speaking on behalf of the board and thus in violation of this policy of the code of conduct. So I just want to bring that to my colleagues for consideration.
Thank you, Trustee Aziz. Move next to Trustee Blackburn.
I'd like to call the question, please.
So we have a motion to debate, to close debate. Is there a seconder for that? Trustee Jenikins, thank you. And a motion to close debate requires also, I believe, 2/3. Or is it a simple majority? So all those in favor of closing debate at this point? And opposed? That motion carries. And that brings us back to the mover for wrap-up.
None required.
In which case I will ask Manager Guthrie to open the vote, please, and remind Trustee Dixon that she is not allowed to vote on this motion. And we have the result. Again, this motion required 8 votes in favor to be approved. We have 3 in favor, 8 against, 8 opposed, no abstentions, and the motion fails. And are there any other motions that are coming forward? As we have now reached the end of our consideration of most of the Integrity Commissioner's report, I will commit as chair that I will follow up with staff in terms of the additional recommendations on the last page of the report with regard to mediation and safety planning and everything else. And we will make sure that we have some updates at Committee of the Whole in camera meetings on those things that should remain in camera. I would like to say a heartfelt thanks to Integrity Commissioner Craig for her report, which was exhaustive and very, very easy to read in some ways because it did form a narrative. Which I certainly appreciated, but of course I'm the one who loves the Dickens novels and things like that. So from that point of view, the detail that was provided, I think, was very helpful to all of us in considering what had happened. And I thank you and look forward to continuing to work with you as our Integrity Commissioner, should we have need of your services. Hopefully not for more code of conduct complaints, but also for helping us to learn how to be better trustees. Thank you very much. Moving on with our agenda, we are now at item 13.1, report from OSTA representatives. Is there a report from OSTA this evening? Trustee Lee?
None required, Madam Chair.
So there is no report required for public. And 13.2, report from our Ontario Public School Boards Association representatives. Is there a report from OPSPA this evening? Trustee Jenkins?
Thank you, Chair. This morning, the OPSPA Board of Directors met and ratified the tentative agreement that was reached with the ETFO teachers and occasional teachers on November the 21st.
Are there any questions for Trustee Jenkins? Seeing none. We have our board work plan on the agenda as item 14, and I remind trustees that the board work plan is intended to keep our focus on what we are hoping to achieve during this school year in the interest of supporting student learning, promoting well-being for students and staff, and advancing social responsibility in the OCDSB. Item 15, we have no matters for information this evening. That brings us to item 16, new business. Is there any new business? And I'm not seeing any new business for the public meeting. Before we adjourn, I would like once again to wish everyone in the Ottawa-Carleton District School Board, students, staff, and their families a joyous and peaceful holiday break and a happy new year. It will be 2024 when we meet again. Having completed our agenda, I declare this meeting adjourned.